Attorney Thomas Burton here, and today I want to give you a quick tip on how married couples can avoid probate on the family home upon the death of the first spouse to die. So many people know that Wisconsin is a marital property state. We call it marital property. It's also called community property in other states, such as California. And what that means is, as a community property or marital property state, there's an easy way to avoid probate on the family home upon the death of the first spouse to die. And that's to hold the home titled as survivorship marital property. So Wisconsin statutes allow it in 760 here, 766.6, if the words survivorship marital property are used instead of the words marital property in the form described, the marital property so held is survivorship marital property. On the death of a spouse, the ownership rights of that spouse in the property vest solely in their surviving spouse by non-testamentary disposition at death. The first deceased spouse may not dispose at death of any interest in survivorship marital property. Holding marital property in a form described in subsection 1 or 2 does not alone establish survivorship ownership between the properties with respect to the property held. So survivorship marital property is the term that you can see we sometimes use on a deed, especially for the family home. It'll say survivorship husband and wife as survivorship marital property. And this is an easy way to avoid probate upon the death of the first spouse to die. Now, there's an additional tax benefit to this because in community property states, the IRS allows what we call a double step-up in basis upon the death of the first spouse to die, meaning the entire property can get reevaluated at the death of the first spouse at the current fair market value. So if you bought the home in 1980 for $100,000 and the first spouse dies in 2020 and the home is worth $200,000, you can get that double step up in basis on both halves for property held as survivorship marital property. So for many couples in Wisconsin, this is the preferred method of holding the family home if they want the surviving spouse to stay living in it and receive their half. If you have a blended family or you want your half to go to your children, you maybe don't want to hold title to your property this way. But for many married couples, husband and wife as survivorship marital property on the deed to the home will accomplish this goal of getting it to their surviving spouse without the need for a probate on that spouse's half on the undivided interest in marital property in the home. So that's a quick tip on how you can do some estate planning through the title of the asset itself, in this case through the deed to the home. And many people buy their home and never look at the deed again. So this is a reminder at the beginning of the new year to look at that deed. I always recommend you have a comprehensive estate plan in place, including a will or trust, powers of attorney, healthcare powers, financial powers, and other things, and work with a qualified attorney to put it in place. But I know some people are also looking for peace of mind about the assets they currently have and are maybe working on their estate plan or intending to do it soon. So this is a quick reminder of one thing you can check and make sure you have the deed set up correctly the way you want it on the home. And if you want to avoid probate upon the death of the first spouse, again, look for those words survivorship marital property. And that will do it for a husband and wife, a married couple in Wisconsin. So thanks for watching. I hope this has been helpful to you. If it has, consider giving it a like or a comment and subscribing so that more people can see these videos and benefit from them as well. Thanks for tuning in, and we'll see you next time.